any book on conflict of laws, especially by all of these European authors, would do the comparison, because just like in Europe, you have countries surrounding one another that do not use the same connecting factor. That is also what we have in Africa. Every former colony of UK will be using domicile, whereas those of the other colonial masters, like the French, the Germans, and the Portuguese, will be using nationality. So it's a live topic. It is the reason why you have Ruva as a concept. Because if you understand Ruva, you will see that the entire basis of Ruva is to say that you want to achieve uniformity of decision, so that if someone, the pronouncement of courts in different countries will not be affected by their connecting factors solely. That's why you have Ruva. So that's one of the reasons why you have Ruva. Anyway, to make sure that if somebody is a national of one country and domicile in another, okay, you will not have a situation where the law that will be employed to determine his personal law will depend on where you are suing. You want to achieve uniformity. That's the reason that has been given for Ruva, especially double Ruva. You want to say that if the man is a national of Nigeria and domicile in Benin Republic, it will not matter whether he goes to Nigerian court or Benin Republic court, they will be pronouncing the same judgment. Okay? And we have said that the whole idea is defeated, where the double Ruva concept is also the concept of the two countries. Okay? So it's a common topic in European texts in this subject area, comparing nationalism with the other one that some of them also talk about is habitual residence. Habitual residence is not exactly domicile. Habitual residence is slightly different from domicile because it doesn't ask for mental element. Okay? At best, it is a more consistent or persistent physical residence. But it will suffer from some of the criticism that nationality will have, because you can have more than one habitual residence. You can have an international person with homes in two or more legal districts, and he spends the year equally in between the two or more countries. So if you have to apply one as one of those countries as a country's law, as his personal law, you will still have the same problem that you are going to have in nationality. So that is the reason why, as technical as domicile is, it is thought to be even better than habitual residence. But we have seen the problem it could create, especially in respect of dependency domicile, for a married woman who has to file a petition to dissolve his marriage only in the place where she is domicile. And because her domicile is dependent on the domicile of her husband. If her husband has acquired another domicile, she might find herself in soup. But we have told you how legislations in common law countries try to help the female sex. Okay? And of course, in England, where we copied all of this, those are no issue again. The dependency domicile of married women is no more in England. They now retain their own separate domicile from their husband, and so they are not regarded as an appendage of their husband Okay, but that is still the position in Nigeria and some other common law countries. And so the only way that married women are being helped is the creation of social domicile, which many of you would have come across in your discussion of marriage and family law. Okay, so you've not done the assignment. You've not looked at the issue. Go and look at it. Today we want to move to marriage in the conflict of laws. And we want to know what is it we are talking about. Marriage is a very big area for purpose of conflict of laws because there are many topics and subtopics. Okay? But what I try to do is to simplify it by beginning from the first thing I will first tell you is that we started by telling you that conflict of laws has dimension in Nigeria. We talk about how many dimensions did we talk of?
3.
How many dimensions did we talk of?
3 dimensions.
3 dimensions.
Well, mention them.
International,
Mention the 3 dimensions.
interstate,
International, interstate, and internal. International, interstate, and internal. Okay? Which of the 3 dimensions must we deal with when we are discussing marriage in Nigerian conflict of laws? Which of the 3 dimensions
Internal.
must we?
Internal.
No. Internal.
And
Interstate. No.
why did you say interstate? Yes, why did you say interstate?
Law for the whole country, so there's no like different marriage laws for different states that would cause conflict.
Yes. So there is no interstate. There is no interstate. Go and look at the statute in the subject area. They are all, as far as marriage is concerned, are federal statutes. The marriage ordinance or marriage act is a federal legislation that applies throughout Nigeria. Also, when you come to the area of matrimonial proceedings, for any marriage that is done under the Marriage Act, the Matrimonial Causes Act governs is nullification of dissolution. Okay? So that is the reason why we do not have an interstate, especially in the area of choice of law, we do not have interstate dimension of conflict of laws. The law, as far as the general law is concerned, will not be different in Lagos as compared to Kaduna, okay, because it is the same statute. That's how you know whether a subject matter has interstate dimension. If a matter is regulated at the federal, okay, by statute enacted by the central legislature, then, and with no power given to the component state to go their different ways, you cannot have interstate dimension of conflict in that subject area. So we have internal. When do you regard, the first thing we will discuss is when do you regard a conflict of law, a conflict of law marriage issue as internal? When do you regard it as internal? Can somebody give me the answer?
Sir, I
Hello?
think that. Hello, sir.
Yes,
Can you hear me, sir?
I can hear you. Let me put off this my television. Yes, I can hear you.
I think that where a student of marriage will be deemed internal, from my own understanding, will be when the parties have issues such as race, religion involved in the facts.
Any other attempt?
I think that like
Hello, sir.
if the people in the marriage, like if they have like different personal systems of law that apply to them, then there might be an internal conflict.
Very well. Very well. You know that conflict ordinarily is when there is a foreign element. So if the marriage you are talking about is between persons whose connection or contact is entirely within Nigeria, then there will be no foreign element. But if one of the spouses or one of the couple is connected with another legal district, and by another legal district in this sense, we are not talking about another state, we are talking of another country. Ipso facto, the matter becomes private international law and not internal conflict. I normally ask this question because in the past we have had cases where Nigerian girls have married men from other countries, and it turned out that the marriage was done under customary law. And long after the death of the men and the issue of whether those women's children were entitled to inherit or not arose, somehow our courts excluded their children from being entitled to inherit on the basis that Nigerians, foreigners had no capacity to marry under our customary law. Foreigners had no capacity to marry under our customary law. So in pointing out the elementary error of the courts in those cases, I have said that those cases were not cases of internal conflict because there was a foreign element, by which I mean there was some contact or connection with another legal district. Okay? And the reason why the distinction between when a marriage issue is an internal conflict issue and when it is a private international law issue is because the source of our law on the matter are different. Okay? The sources of our law on the matter will be different. If the case has one element and you are talking about applicable law, then received English law is the source of our law. But if the matter does not have a foreign element, everything about the parties and everything is Nigerian. The conflict is internal, and received English law cannot solve the answer. Okay? So some of the cases I'm talking about include the case of Fonseca and Passman. I'm sure many of you would have come across that case. in a legal system. Fonseca and Passman was the case where a Portuguese married a Nigerian native, the Portuguese being the man and the Nigerian native being the woman. And long after his death, the question was whether the children were entitled to inherit. And the question of his marriage therefore arose as an incidental question. Okay? And at the end of the day, what the court seemed to have decided was that because the woman had no capacity, because the European had no capacity to marry under customary law, there was no marriage, and the children were not entitled to inherit. And you will find legal system texts trying to criticize that case, but they really did not pin their criticism on any valid conflict of laws argument. The correct conflict of laws argument is that the case was not an internal conflict case, because the element was clearly foreign, since the supposed husband was not Nigerian, he was Portuguese. Okay? So what they ought to have done is to take their rules from the common law. In other words, to ask themselves what an English court would have done in that type of circumstances. But they thought that this was a question for which they will find answer within the statutes of Nigeria. So they used those presumptions in section 26 of the High Court laws. The one that says that if the transaction was between a non-Nigerian and a Nigerian, there's a presumption that it cannot be governed by customary law. And they also sometimes will refer to the customary law, the customary court laws. Customary court laws. In all of these, they say that foreigners are not subject of the customary courts do not have personal jurisdiction over foreigners. So for those reasons, they would conclude that, sorry, there was no marriage, or there was no marriage because foreigners had no capacity to transact under customary law. If only they had treated the matter as a proper matter for private international law, they would have been well guided, and the answer may have been different. As we go on, you will be able to appreciate what type of answer they should have given if they had treated the matter as a matter falling within the private international law dimension of our conflict of laws, and not the internal law dimension of our conflict of laws. For me, it is a matter falling within private international law dimension of our law, because the marriage was not between two Nigerians. Since a foreigner was involved, that is somebody who is connected with another legal district other than Nigeria, then the matter has a foreign element. And what they should have consulted was Nigerian choice of law in the area of marriage. So even if they want to answer that incidental question of marriage, and they want to use Nigerian law to answer it, the appropriate Nigerian law they will use to answer it is Nigerian conflict choice of law rules. And Nigerian choice of law rule is received English law on the matter. And that is why I said, if they had asked themselves, what will an English court do in this circumstance? Okay, an English court in this circumstance would not have arrived at the decision they arrived at. No way, there is no chance an English court would have ended up excluding children born to marriages where the marriage is not a nullity where it was done. They would not have excluded children born to such marriages from inheritance. Okay? They would not have done so. But here we are, lack of understanding of the subject and of the difference between internal conflict and private international law led the court to just give one answer. And then the answer becomes a controversy. Even those who are criticizing the answer, they don't know the basis upon which to criticize it. Okay? So be that as it may, we now understand that marriage in our conflict of laws can throw up either private international, that is where there is a foreign element, that is some connection with another country, another legal district, or internal, where the marriage is purely between two Nigerians, no foreign element. Reason being that marriage is a subject of legal pluralism. And I told you, I don't know whether I told you or you must have, if you have read my write-up, I said when you are talking about legal pluralism, there are always three questions. Any of them can come up at any time. The first one is the question of amenability. Who is amenable to which personal system of law? The second one is possibility of change. A person who is amenable to a personal system of law, are there facts that we can employ to say, no, he's no longer amenable to that system, he's amenable to another system? That is the one that you use, you look at cases like Olowu and Olowu, or Adesupoka Yunusa, and what have you, okay? And then the third one is transaction or interaction or relationship